Prince Andrew had raised a number of defenses, including most prominently that the settlement agreement between Mr. Epstein on the one hand and Ms. Giuffre on the other back in 2009 precluded the lawsuit that she has recently brought in federal district court. In other words, he claimed that he was a third-party beneficiary of that agreement based on some language in the settlement agreement from 2009 that purported to release certain, quote unquote, other potential defendants. And so the question primarily before Judge Kaplan on this motion to dismiss was, is that language ambiguous? That is the question of law that was in front of him. And he decided, yes, it is ambiguous. Another question in front of Judge Kaplan for the purposes of this motion to dismiss was the constitutionality of the New York Child Victims Act, which reopens for a limited period of time the statute of limitations for victims of child sexual abuse. And he also found very handily with respect to that argument that there was no issue of constitutional magnitude, and that in fact the legislature had every right and reason to open up the statute of limitations, and that was not a defense for Prince Andrew in this case. It's significant insofar as it, of course, permits the case to proceed. So there will be discovery. Prince Andrew will be deposed. Other witnesses, including third parties, will be deposed. Documents will be produced. So a record will be created above and apart from the record that was created in the Maxwell case and in multiple other civil lawsuits. The plaintiff is permitted to move forward with her case and to try to build out the factual allegations in her complaint. There may well be an amended complaint once she learns additional facts, if she does, and eventually there may well be another motion for summary judgment at the conclusion of the discovery in this case. And if that is denied, as the motion to dismiss was denied, and I'm not prejudging that, of course, no one even knows what arguments will be made, but if that is denied, then it will go to trial. He will aggressively go after her deposition, previous statements she's made, and we know that she has made many in the press, and I believe she's testified in other proceedings, and she will have recorded statements. And so he will look at those and try to discern whether there are any material discrepancies. So he will do everything he can to undermine her credibility. There will be numerous disputes along the way that will slow down and gum up the process. But eventually it will conclude unless there is some disposition, unless there's a negotiated settlement agreement between the parties. That often happens. Here, it's, I would say, it would be doubtful, just given the positions that people have taken and given the very public nature and given the defendant's very public profile.